Okay, so this is Austin's book, How to Do Things with Words, Lecture 2. By or in saying something, we do something. So by or in saying something, we do something is not always the case. Saying something is not always doing something. We must take the time to learn something. Performatories or performatives look like statements, but we are wrong. They are not just statements, they are actions we are performing. So we see how categorizing them as true or false does not work. I do take this woman to be my lawfully wedded wife, as spoken as part of a marriage ceremony. We are doing, performing, acting. We are marrying, performing the act of marrying. Like bedding is to say certain words. It is worthy to note, as I am told, in the American law of evidence, a report of what someone else said is admitted as evidence if what he said is an utterance of our performative kind. Because this is regarded as a report, not so much of something he said, as which it would be hearsay and not admissible as evidence, but rather as something he did, an action of his. This coincides very well with our initial feelings about performatives. So I think what he's saying is, instead of saying, he said this, you say, I heard him say this. You also have to have appropriate circumstances. Someone might say, I bet, but just saying it does not make it so. Other things must be done to have properly performed the act of betting. Many of us may find it compatible to offer an acceptance. What can go wrong? He talks about infelicities. First, look at what is to occur. I summarized the list. This is my summary of Austin's list, which I'll go over in the end. Speak it to be the appropriate people, correct procedure, done completely, mutual agreement of designed procedure, and then act it. So act as though you're married, act as though you have made a bet, etc. We have what Austin calls complete performances, such as 1 through 6. When done properly, we call happy. So when 1 through 6 is done properly, it's considered a happy performance. And he contrasts that to when something goes wrong, it's an unhappy performance. And this is, instead of using the words true or false, since performatives are not really true or false, since it's not a true or false statement, it's something we are actively doing right now. Unhappy performances might be called a misfire, such as when the procedures are in some way botched. It is void or without effect. Abuse is when something is not done sincerely, such as I promise with no intention to keep the promise. So if you get married and you consummate the marriage, but then you start acting as though you're not married, then it's insincere. So he calls these two things a misfire or abuse. So a misfire is when the procedure in some way is botched, and abuse is when you were not sincere about what you were doing. It might be an attempted act, but that does not mean that nothing was done, okay? And he compares this to a bigamous marriage. So, for example, a bigamous marriage occurs, but is void, empty, without effect, botched, hollow, etc. So I compare this with the information that that I go over in my videos with things such as positive law. So it's not that something didn't exist, it's that what is botched in some way. It's void, it's empty. So my note is, this is my note, not Austin. The positive law citation is a form of law, is like Title 26, the IRS code does not have a positive law citation. So what we call it is a form of law, but a form of law is no law at all, which is what he says. For example, it's a bigamous marriage. It's not that there's not a marriage, it's that it's not a marriage in the way that we see marriage. So it's botched. But then that marriage is void because it's bigamous. So without a positive law citation, it's not that it's not a law, but it's also not considered a law because a form of law is no law at all. So what I tell people is that it's a type of contract, and once you sign a contract, then it becomes a law because you've agreed to it, you've promised in some way. Like a traffic ticket, when you sign a traffic ticket, the ticket on top may say, I do hereby promise, and then you sign it. So you've made a promise, you've made a type of contract. So when you have these, such as Title 26, that doesn't have a positive law citation, it doesn't conform to the procedure of being constitutionally made and then qualified as a constitutional law and then given a positive law citation. It didn't meet the procedure 1 through 6 that I went over, which I'll read Austin's in the end of the video. So a form of law is no law at all. These are the laws, what we think of as laws such as Title 26 that do not have a positive law citation. It is like a misfire or is botched, is void, without effect, because it does not meet the qualifications of being a law and therefore has no positive law citations. The courts cannot see it as a law properly having been made because there's a procedure for a constitutional law that's been made, that it has to follow the procedure in order to have been given a positive law citation. Without the positive law citation, the courts cannot see it as having been made a law. They see it as a contract, in which case the lawyers might present the contract in court. I don't know. Okay, without effect does not mean without consequences. Results of effect. Okay, so that doesn't mean nothing was done, especially if you've signed the forms that they present to you. This is why they have to get you to sign things, because the things that they're presenting to you that don't have a positive law citation, and I'm talking about federally, they're not laws. So if it has a positive law citation, it applies on the federal lands, and you're already under contract when you join the military or you receive a commission as a commissioned officer, you're already under contract to follow the constitutional laws that have a positive law citation. Off federal lands, they have like Title 26, the Education Code, highways, and all those kind of things that don't have a positive law citation, which means you have to then do something. You have to get a driver's license. You have to file forms somewhere. You have to agree in some kind of way. You have to sign stuff. And that's how they get us under these so-called federal laws that aren't really laws because they don't have a positive law citation. But that doesn't mean that nothing was done because you've signed a contract. So something was done. So he also talks about infelicities. A misinvocation. Now again, we're talking about 1 through 6. The procedure of things, the way things go. There's a procedure, just like there's a procedure to ensuring that a law follows the constitutional dictates and follows the Constitution itself. And when that procedure is followed, it's given a positive law citation. That's the procedure. That's the process of it properly being made. Speak it, so they have to read it, right, on the floor. The appropriate people, the duly elected people. Correct procedure, done completely. Mutual agreement of design procedure, which is already mutually agreed on in, the Constitution and the laws that they pass. And then act it. So they have to follow the laws. The law has to be followed. It has to be done. Okay, so the infelicities are a misinvocation due to there being no procedure. A misapplication. A procedure exists but cannot be applied to this particular situation. A misexecution, a flaw in the procedure. Okay, and then we go to outrageous statements. Outrageous statements may be reference to a thing that does not exist. This might include giving away something in a will that does not belong to you. This is not considered a false statement, but is called void. Actions in general, but not all actions, are, quote, liable to be done under duress, by accident, a mistake, or unintentional. We cannot just say it is done or he did it. So they can pretend in Congress that they've passed laws, but these laws can't be given a positive law citation because they weren't, the procedure in some kind of way was flawed. It was a misfire, it was an abuse, it was where did it go? It was an infelicity of some type, a misinvocation, misapplication, or misexecution. Again, I'm going to read his writing of it at the end of the video. I just gave a quick summary, okay? So, actions in general, but not all actions, are liable to be done under duress, by accident, a mistake, or unintentional. We cannot just say it is done or he did it. Another sort of infelicity is from misunderstanding, such as the promise. 1, it must have been heard or agreed to, must have been understood to be a promise. That's why they have to tell you it's a promise. I hereby promise to, and then you have to sign it. So you understood it as a promise because the words were written on the paper. And 2, you heard it or you agreed to it because you signed it. If one or both of these are absent, doubts arise. Okay, so I was given a traffic ticket for not registering my vehicle, and I did not sign the ticket. What I did was I wrote on there, Texas Jurisprudence, 3rd edition, ... Republic of Texas, ... And I gave the ticket back to the guy, and they dismissed the case. I'm not saying that was why, but if you apply the requirement of the procedure to have been followed, and I didn't hear the promise because I didn't sign the ticket, so I didn't acknowledge that I promised anything, then if they're following Austin's procedures, they would have to dismiss the ticket because I never heard the promise. The procedure wasn't followed. Okay, let's see. In law, special precautions are taken, such as serving writs or summonses. Then there is the authority to do a thing. A person must have the authority to do a thing. A sane person has the authority to get married. A person cannot make his own bet. A designated person a person can make his own bet. So I can't make a bet for you. You have to make the bet for yourself. I have to make the bet myself. A designated person can christen a ship, but an undesignated person cannot. Now, he can perform the act of designating the ship, but the ship is not automatically christened because some random person walked by and designated the ship. If a person is insane, he cannot be married. If a person does not own a thing, he cannot offer it up for a bet. If a person is not designated to name a ship, he cannot name it. The form may be proper, the procedure may have been followed, but without proper authority, nothing is done. So this is where I start talking about the people in Congress right now using the Constitution as their power source aren't actually the proper people to be administering the offices created in the Constitution, because they are not qualified, and they're not qualified because they have no military experience. And being a citizen of the United States, in my opinion, my perception, and from what I've read, being a citizen of the United States and 6 years or 9 years or 14 years resident of the United States or citizenship of the United States means you were in the military for that period of time. That qualification does not exist to be in the Supreme Court. It's only good behavior. So if everyone is required to be a citizen of the United States, why is it not that a justice of the Supreme Court has to be a citizen of the United States? And my opinion is that because citizenship of the United States is limited to having served in the military. So why would you want someone to be president and also be commander-in-chief who has no military experience? I wouldn't. So this is what Austin says about the process. This is right out of his book. A1. So A and B are what I named 1, 2, 3, 4, 5, 6. So 1, there must exist an accepted conventional procedure having a certain conventional effect, that procedure to include the uttering or speaking of certain words by certain persons in certain circumstances, such as the marriage, the christening, the bedding, or to read the law on the House floor. And further, the particular persons and circumstances, the correct people in the correct office with the correct qualifications in a given case. So for marriage would be sane, already unmarried, of the correct age, and having discussed the marriage with the other person, the partner. So the soon-to-be husband and soon-to-be wife would discuss it before they got married, and they both agree. Given case must be appropriate for the invocation of the particular procedure invoked. So someone else can't go stand in your wedding and say the words for you and you're married. Someone else can't stand on the House floor and read the law and then the law is made. It has to be the appropriate people. The procedure must be executed by all participants both correctly and completely, where, as often, the procedure is designed for use by persons having certain thoughts or feelings. We agree to get married. We agree to make this bet. We agree that you're going to go christen the ship for me. We agree that you've been voted into office because you're qualified and that you're sitting in a constitutional office and that you can pass constitutional laws. We all agree. Persons having certain thoughts or feelings are for the inauguration of certain consequential conduct on the part of any participant. Then a person participating in and so invoking the procedure must in fact have those thoughts or feelings, and the participants must intend so to conduct themselves, and further must actually so conduct themselves subsequently. And we can't claim hearsay. It has to be fact. I did that. Okay, and again, I shortened the procedure down as much as I could. Speak it, the appropriate people, correct procedure, done completely, mutual agreement of designated or designed procedure. We all agree this is the procedure, and then act it. Act as though married, act as though bedding, etc. Okay? So when we act as though the law has been made and we sign all their forms and their contracts and everything, then we're acting like it's a real law, even if it's not and doesn't have a positive law citation. That's my interpretation of lesson 2 and J.L. Austin's How to Do Things with Words. So I think this book can be downloaded free online. I'll look for a link today, and if I find it, I'll post it in the comments so everybody can see it. It's lesson 2. I encourage you to read it for yourself. He says a lot of things in here that I don't say because it would make the video too long. We're already at over 20 minutes. So, yeah, a lot of good information in here. The very end, he's got a conclusion. I can't wait to go over it. It's going to kind of, I think, blow your mind a little bit about what he says about words and who can use them and who's authorized to use them and what they mean to us. Okay, so with that, I'll see y'all in the next video. I hope you enjoyed this podcast, and please like, share, and subscribe so that we can get this information out to people who really need to hear this, so that we can all start experiencing maybe a little bit more freedom in our lifetimes. Okay, we'll see you next time.